jumping right in, we're going to talk about establishing an entity. And the first question is, why do you do it? Well, there's a number of reasons why it might make sense to form an entity. The most important one is really the last one that I have on the list, which is to limit your personal liability. The most common entity choices, at least the ones that we recommend, we'll talk about limited liability companies and corporations. One of the fundamental premises of those entities is that the owners of the company are not personally liable for any of the debts of the company itself. So what that means is there's a shield there that protects your personal assets. So if something bad happens in the business, there's a huge unexpected debt that comes up, the worst that can happen is the creditors can get access to the assets that are owned by the business, but they can't get your house, they can't get your car, they can't get your savings account. The other reasons are of interest too. Dividing the pie, if you're entering the business with more than one co-founder, you may want to allocate who owns what percentage of the stock, allow or prevent transfers of ownership, agree on the governance rules, how you make decisions and how you handle disputes, and you achieve a form of immortality in the sense that when you form a company, by default it stays in existence forever unless something happens to dissolve it. So here are the choices that you can think about. The first is a sole proprietorship, which is just an alter ego of you personally. It's not an entity, it's just you doing business under a name. And then the two that we'll talk the most about are corporations and limited liability companies. You may have heard of the concept of an S corporation. An S corporation is just a tax election. It's not a different type of corporation, although the election with the IRS does impose some restrictions on the company that we'll talk about. Two that I'm going to tell you to ignore are general partnerships and limited partnerships. And the reasons I'm going to ignore them, and you should too, is they're generally always wrong for launching a new entrepreneurial business. So sole proprietorship, I mentioned, is just an alter ego. It's just you doing business under a name. There's no liability protection. All the income and the losses are yours personally, and whenever you die, the business dies with you by default. It's rare that this is really the right choice. If you are truly a small sort of popcorn stand kind of business, then yeah, it may not make sense to set up an entity. But if there's any sort of expectation of growth or value creation in the business, you really should form an entity with that liability shield. So here are the two main choices that we talked about. And I'll sort of walk you through the differences, and then I'll give you a quick recommendation on how we generally advise our clients which one to choose. A corporation and an LLC. A corporation has bylaws, and the analogous document in an LLC is called an operating agreement. This is the document that sort of sets forth a lot of the rules and procedures for how the business operates, how meetings are conducted, how voting takes place, that sort of thing. A corporation is required to have a board of directors. The board of directors is the primary policy-making body for the organization, so it makes all the major decisions and is usually responsible for hiring the senior management team that then would hire the employees underneath them. An LLC can have a board of directors or not. You have choices there. A corporation has officers. Usually at minimum, it'll have a president and a secretary, but you can have whatever other officers you want. An LLC can have officers or not, so you have choices there. A corporation, by default, there are two levels of tax. So the corporation is taxed like a person, just like you or I, and its income is subject to tax. And then when the corporation distributes dividends to the shareholders, those dividends are also taxed to the shareholders. So there's two levels of tax. If you are an S corporation, there's only one level of tax. It's only taxed when the money is distributed to the shareholders. LLCs are a pass-through entity, so there's no tax at the entity level. So here's sort of the upshot of it. Corporations are fairly rigid in how they're structured, and LLCs are fairly flexible in how they're structured. I like to think of LLCs as a choose-your-own-adventure entity. You can sort of make them do whatever you want. So how do you figure out which one's right? Generally speaking, if you are on what I call the venture capital or bust path, meaning you're going to have to raise significant outside capital for your business to be successful, or it won't be successful, then you should start off as a corporation and likely a Delaware corporation, and I'll talk about that in a second. And the reason why you should start off as a corporation is because you're going to end up one eventually. Venture capital firms generally can't and won't invest in LLCs because that favorable tax treatment that I mentioned earlier actually creates some tax and accounting problems for the venture capital funds. So they will generally not invest in LLCs. As a point of fact, if you are an LLC and you go that path, it doesn't preclude you from getting investment money. What will happen is your venture capital investor, when they present you with a term sheet, will actually require you to convert the entity into a corporation as part of the transaction. It's commonly done. I'm doing 2 venture capital deals right now where that's part of the process. And the reason we recommend Delaware, and I brought an honest-to-goodness Delaware lawyer with me here, the reason we recommend Delaware is because Delaware's got the oldest and most respected body of corporate law in the country. Every corporate lawyer in the U.S. is comfortable and familiar with Delaware law. So if your investors come from outside of your home state, they will be happy to have a Delaware entity because it's familiar with them. If you're not a Delaware entity, it doesn't mean it's wrong. It just means there's extra steps that the investors are going to want to take.
Hey, Chris, let me jump in 1 second, because this is just one of the principles, and it's an interesting one we come across a lot when we're working with people who are starting companies and really trying to figure all of this out. There are a lot of different variations you can get into, particularly when you get into LLCs, when you're trying to do states. There are a lot of tricky things you can put in there that may make absolute sense for your particular situation. But at the end of the day, if your path, as Chris is saying, is to go get money, think about Jim and his statement, cash is king along the way. What you want to do is have a structure that people understand. They don't have to spend a whole lot of time working at it, which again makes LLCs a whole lot harder. They get a lot more complicated. People have to work harder to understand them. People know Delaware corporations. They're easy. They just don't have to think too much. You don't have to then spend the money to convert down the road, which is again taking valuable resources. Sometimes you can do something that may not work quite as well for you, but it's a known entity. It's simple. There's some standard forms that investors are used to seeing. And yeah, it may not be always in your interest, and you have to understand that. But sometimes just being simpler saves you a lot of transactional costs along the way. It saves you legal fees, saves you negotiations, and cut back.
I'm expressing an opinion here. I don't think today, with the modern LLC statute, there's any real reason to use an S corporation. At this point, it's not wrong to use one. They work just fine. But there's nothing you can do in an SCorp, for the most part, that you can't do easily or flexibly in an LLC. So we generally steer people to either LLC or C-Corp, but nothing wrong with an SCorp. It's just very restricted in terms of the number of shareholders you can have, who can be those shareholders. So it imposes some limitations that an LLC doesn't have. Okay, so you've decided you're going to start a company and you've decided you're going to be an LLC or a corporation. You're going into business with one other person, at least, maybe multiple other folks, and you've agreed on how the pie is going to be divided. What else do you need to think about? Well, you need to have some sort of agreement in place with your other founders to protect you all and make sure that your expectations are aligned. So a couple of the issues, and in a corporation, this would be called a shareholders agreement, or it could be called a voting agreement or a buy-sell agreement. They're really just variations on the same thing. In an LLC, it's an operating agreement or an LLC agreement. So here are some of the issues that you typically want to talk through with your co-founders. Transfer restrictions. Do you want to restrict the ability of any of your co-founders to sell any of their interests to a third party? Typically, yes. You typically would have what's called a right of first refusal. That's the ROFR that you see that simply says if they want to sell to someone else and they have an offer, they have to present that offer to the other founders of the company first. And otherwise, you would prevent them from transferring it. The other category of transfers that you might deal with are what we call involuntary transfers. So these are situations where somebody dies, somebody gets divorced, somebody goes bankrupt. There's a list of issues that you might want to deal with. It's a little more complicated because you have to then figure out what's the value and how are the payment terms going to work. But this is an issue you should discuss with a business lawyer. Governance and voting and deadlock. This is particularly important if you go into this 50-50 with someone. Well, if you're 50-50 and you disagree, how do you break the tie? That's something to think about. There's a number of fairly common ways. There's also a lot of creative ways. I actually have a client that's here in Cool Springs that has in their LLC operating agreement that they will break a deadlock with a golf scramble and with a golf match. And I didn't believe them until they showed it to me in their operating agreement. And it's in there, and it's a page and a half long, and it says they're going to play this course, and he's going to play these tees, and she's going to play these tees, and he's going to get this many strokes, and this person's going to be the witness. I mean, it's very detailed. And I've never had to use it, but that's the way they chose to address it.
Is that match play or total score?
Good question. I don't remember. So.
I did one the other day that required the two people before they had any dispute to sit down over a glass of Jack Daniels. It was written into the agreement.
Right.
And they at least had to sit over a glass of Jack Daniels before they went to that next phase. So I figured, at least if we're sitting there drinking, we can work out.
Everything's like the drink.
Right. So the point here is that there are certainly some standard options, but there's no right or wrong answer as long as you all agree on a process that will allow you to resolve the disagreement. This is particularly important if you're going into this with friends or family, because I promise you nothing will get in the way of friends or family faster than money. So take advantage of it on the front end and preserve the relationship by putting a carefully constructed agreement in place. A couple of other things to think about. You may want to include what we call a drag along, and this is simply the notion that if 80% of the shareholders want to sell their stock to someone else, the 20% can't prevent them from doing it. And then if you haven't separately addressed confidentiality and intellectual property ownership, which Edward's going to talk a little bit about later, you can include that in this document, although it's typically handled separately. One last topic before I flip it over to Bruce to talk about a couple things. You really should strongly consider having a vesting agreement in place between the co-founders if there's more than one founder. And it's for the simple fact that usually you're going into the business with the expectation that you're all going to be actively working on it. And if one of you up and quits 6 months into it, the others are going to feel somewhat disappointed or frustrated by that in most cases. And it could be someone quitting for a variety of reasons: good, great job opportunity, bad, you all hate each other, or ugly, someone dies. There's a lot of reasons why it can happen. But you should ask the question because by default, if you don't have an agreement in place, that person keeps the equity and you can't force them to give it up. And so generally we recommend that founders include a vesting agreement for all of their own equity that vests over some period of time, usually 3 or 4 years. And if they leave in that period, then it goes back to the company or it gets distributed to the other founders.
Who owns what of your company? And being able to show a prospective investor that you have kept those records means a tremendous amount. And we're going to talk to the capital panel this afternoon, but they will generally tell you if they come in, they don't know who owns the company, they're walking. They're trying to limit their risks. They're trying to figure out what they have. If they have to work too hard, you're not going to get that capital that you need desperately to run the company. Every time someone transfers stock, you got to keep that minute books. You have regular meetings. It's important to show that you've had regular meetings. It's important to keep track of what you do. And all of these things are very, very hard for people starting up companies. There's so many things going on. It's always something you're going to get to. If you start and you do it regularly, you keep up with it, it matters greatly down the road as you enhance the value of your company and are looking to sell it, or looking to get investments, or bring other people in.
Yeah, and I'll add that you don't have to keep these in a paper binder, which is sort of the traditional way to do it. A lot of companies these days will keep them online in some place like Google Docs or Dropbox, and that's fine. But as Bruce said, the important thing is get in the habit of doing it early, and then it's not difficult to maintain.
Once you have to try to make up 3 years of records, it's pretty tough.
Bruce and I both been through those.
Yeah. Okay, securities laws basics. Again, this is the subject of at least a semester class at law school, but I'm just going to hit a couple points that you need to know as entrepreneurs. So securities, again, this is stocks, options, warrants, and promissory notes. Basically, ownership in the company, loaning money there. Think of that as securities. Those are your red flags that are going up. So again, if you're selling interest in your company to an outside investor, that's a securities transaction. They're investing in your company. There's regulation both at the federal level and there's regulation at the state level. And so if you're thinking of selling ownership interest to people in multiple states, now you have to consider federal level and multiple states. Again, it's not an insurmountable task, but keep in mind all of these have issues associated with them. Private placement. So in general, kind of flying down, I am going to issue stock in my company. In general, what the law says is I have to provide a certain amount of information to my investor unless they fall in a specific class where they are an accredited investor, a more sophisticated investor, who the law will assume that they are sufficiently sophisticated to ask their own questions. Otherwise, if I'm selling it, onesies, twosies to my neighbor next door, I have to provide a lot of information. If you're going to put that book together, that kind of information that's going to satisfy you so they don't second guess you after the fact and say, hey, you didn't tell me this key thing I needed to know, that can be a very, very expensive endeavor. More so, you usually put your business plan and other things there. As an emerging company, you look at what Jim kind of talked about, your business plan changes 100 times. It's impossible to fix it and spend that time putting that book together. Which is why most people want to go out and sell it to higher worth individuals, accredited investors, and that's generally, I think it's $200,000 for an individual, $300,000 jointly in 2 years in a row of salary, or $1 million net worth exclusive of home at this point in time. That's your general definition of accredited investors. People
It's a
with lot
proxy
more
for
money.
rich people.
Rich people. But what the law says is rich people actually can afford to take the risk and they can do their due diligence. So when you start getting out and you're talking to angel investors, you're talking to venture companies, capital companies, and others, that can be a whole lot easier in terms of the information you have to provide them. If you're just selling to your neighbor, that's great in some sense, but you actually have some exposure from a securities perspective. And I want to say one word quickly about unlicensed brokers, dealers. If you're getting someone, and there's a whole cast of characters out there that will say, I can help find you money. If they're helping you find money and they're taking either a piece of the transaction or a fee that is based on how much they raise for you, they are required to be licensed. If they are not licensed, and I will tell you, there are a lot of unlicensed people out there raising money successfully, but illegally. There are ramifications back to the company, not the least of which is if an unlicensed broker brings someone into the deal, it gives that person a right of rescission. They don't like the way the company goes 2 years from now, they can come back to you and say, give me my money back, and you have to give them their money back. They usually don't ask for the money back if your company is successful. They ask for the money back if your company is tanking and it gets to be tough. The other part about having an unlicensed person out there, you can get into a lot of trouble to satisfy the exemptions, to do, I didn't talk about accredited investors and the specific exemptions, but to satisfy your specific securities law exemption so you don't have to register. You can't be out generally soliciting investors, telling everyone that you've got something. It has to be private, has to be done in a controlled manner. You can be talking to accredited investors. If you have someone that you don't have control over, who's an unlicensed broker, you can blow all those exemptions, and there are a lot of repercussions.
There's different ways of issuing equity incentives to your employees. I listed the three main ones: stock options and restricted stock, which work in an LLC or a corporation. In an LLC, you have another option called a profits interest, which is sort of like non-voting stock. There are tax issues with these equity incentives, and you typically want to put a vesting restriction on them. The standard Silicon Valley vesting model is 4 years, with the first year being a cliff, meaning that nothing vests until the end of the first year, and then it goes monthly or quarterly after that.
Just a couple different things, employment law classifying workers. We'll give you these slides. Obviously, you're going to kind of leave the academic environment where they're grad students, you're now building a company, you're bringing people on board. You can bring them on board as employees, you can bring them on as independent contractors. There are different things that you need to be aware of with them. Again, at-will employment, Tennessee's a great state for that. That means if you terminate somebody, for the most part, unless they've got an agreement that specifies what happens upon termination, you can terminate them. You're not obligated to do a whole lot of different things.
No, there's a lot of misinformation about non-competes out there. Most states will enforce them if they're properly drafted, and generally it has to be reasonable in its scope and duration. Tennessee is a state that will enforce them. The only one that generally outright won't is California, but it's usually a good idea.
But very important, especially when you're hiring employees, to understand whether they have an existing non-compete. And we've run into this issue an awful lot where you get great companies, but they hire somebody, don't understand the scope of the non-compete, and then often end up fighting with that other company. Again, then usually end up fighting if your company is successful, and the other company is saying, hey, I want a piece of that. Depending upon the nature of what you're doing, it's sometimes hard for the people to separate the intellectual property they leave one company with and start with at the next company. And it gets fuzzy, and if you have to go in and talk to a state law judge who may or may not have that technical background and tell them why your company, which is doing some particular niche of an internet-related analytics kind of piece, is different from this other company, which is also doing something involving internet analytics, it gets pretty tricky, and you're really kind of rolling the dice, and it can be very, very expensive. So that can all be avoided if on the front end you understand what the non-compete is, and if it's kind of a gray area, you may want to think hard about that employment decision.
Okay, a couple minutes on contracts, and then we'll turn it over to Chuck. So first, what is a contract? It's a promise that's supported by consideration. So consideration can be anything of value. It could be money. It could be an agreement to do something or an agreement to not do something. It could be the actual act of doing something. If I offer to buy Bruce's car for $1,000 and Bruce agrees, then we've got a contract for me to buy Bruce's car for $1,000. Contracts do not have to be in writing. Some, perhaps most, oral contracts are enforceable. There are some exceptions for certain things related to wills and trusts and certain types of real estate documents. The problem with oral contracts is proof. We have a saying in the legal profession that if it's not in writing, it didn't happen. What happens is you get into a dispute with somebody that you had an oral agreement with, and you get into what Southern lawyers call an old-fashioned swearing contest, where I swear he said this, and he goes, no, I swear I didn't, and the judge has to figure it out. So written agreements provide that proof, and they provide that clarity. And keep in mind that written does not mean formal, printed, bunch of fancy Latin-looking words and a notary. You can have an exchange of emails saying that documents the agreement, and that can suffice as a writing for proof purposes. Get the whole deal in the contract. If there's some provision that's important to you, make sure it's in there. Similarly, if the contract says something that's not what you're expecting, don't let it stay in there. Don't fall for the old, oh, I know that's what it says, but that's not the way we actually do it. Or we'll agree that we won't do that with you. Because what happens is people get fired, people quit, people leave, people get promoted, and all that the next people have is what's in the contract. Don't rely on that. If it's important to you, make sure it's in there. And then the last piece is what I call the law of common sense. Read it, make sure you understand it, and then ask questions if you don't. And if you get to something like this where it doesn't make sense to you, then it probably needs to be written more clearly.